Who's on the Galaxy 10 with the sun in their face?
Oh, that's me. My name is Janice.
What's your name?
My name is Janice Bowser Glue. I am a staff for Cody Carr.
These are what for Cody Carr?
She's the staff.
I'm a staff at the home.
Oh, okay.
Yeah, I'm a staff at his home where he lives.
Okay. Cody Carr here?
He's with it.
He's with you?
Yes, he's right here. Say hello.
Okay, very good. Charges, is that what it is? Okay, Mr. R. On the record in the matter of the people of the state of Michigan. Oh. Who's she? And shoulders and the hell. We'll call it next then. Okay, we gotta wait for Mr. Har's attorney to appear. On the record in the matter of the people of the state of Michigan versus Cedric Hennessy, file number 23-01840, council appearance.
Prosecutor Paige Petrowski on behalf of the people.
Your Honor, Assistant Public Defender Stephen Feigelson. Mr. Hennessy was here. We were leaving the matter on for an exam. So I was under the impression we weren't going to be going on the record, Your Honor.
Okay, sounds good. Which one did you?
Gary Thomas.
Oh, Thomas, okay. Continue to exam for Hennessy.
I think he left the jail, Your Honor, Mr. Thomas. I don't see the light in the room on.
I'm not sure. Is Gary Thomas there? He wants to waive. Is that what you want him to do?
Correct, Your Honor, but we can do that next week if they can't bring him back in.
We can call the jail and see if they can bring it back in or do it next week. It's up to you.
Whatever your preference is, Your Honor.
No, we can do it today. Can we call the jail and see if they can put
Enough for
Mr.
me.
Thomas back in?
I'm not able to jail.
No, you're not. No, you're not. No, you're not. We're just here to talk to the judge.
Okay, Mr. Starks, you had Snyder with you.
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Thomas Snyder and file number 24-00676, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Mr. Snyder. Mr. Snyder is present at council table for staying.
Okay, how are you, Mr. Snyder?
Okay, how are you doing?
I'm well, thank you. Today was the date that was set for sentencing on one count receiving and concealing stolen property less than $200. I do have a pre-sentence report. It was dated prepared May 13, 2024. Council, did you get a copy of that?
You did, Your Honor. Thank you.
Okay, any need to make corrections, updates, or deletions?
Nothing from the people.
Nothing from the defense, Your Honor.
You can make allocation.
Thank you, Your Honor. Mr. Snyder is very sorry for what he did. He understands the importance of making better decision-making choices in the future. He has been working with CMH. He's continuing to follow with his CMH care. He will continue to do so. Respectfully, the recommendation of 6 months of probation is certainly fair and appropriate. Mr. Snyder will embrace the opportunity to prove to the court that he could be rehabilitated and stay out of trouble in the future. Thank you.
Mr. Snyder want to say anything for himself today?
No.
Okay. I reviewed the pre-sentence report as well as the prior criminal history of Mr. Snyder. I agree with you, Mr. Sarks, that the recommendation is appropriate. That's for him to continue to mental health counseling, have a brief time of supervision by the court, and then participate in moral recognition therapy. So the court will adopt the recommendation. Sentence will be for 6 months probation. While on probation, there is a $30 per month oversight fee. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription, okay? I'm sorry?
It's okay.
Okay, you're gonna be required to submit to random preliminary breath testing and your analysis testing. You're responsible for the cost of that, okay?
Okay.
And you're not to be at any bars or any nightclubs. I am gonna order that you continue mental health counseling at CMH and provide verification to probation. You don't have to assign a release of information. I'm also going to order that you complete moral recognition therapy, okay? Any questions regarding your probation status and the conditions of your probation?
No.
There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that will be assessed. We'll waive discretionary fines and costs. 6 months of probation will be $180. A total of $305, which will make monthly payments on that, okay? Lastly, there's an advice of right as to probation. You have the right to request early discharge from probation once you've completed 3 months of probation, so long as you've not violated within those 3 months, okay? You would get the form from your probation officer, or you can get it directly off the court website. You'll complete that form, you'll give a copy of the form to probation, and you'll have to serve a copy of it on the prosecuting attorney's office. The prosecuting attorney's office has 14 days to respond in writing with any objections to your request for early discharge. If I set it for a hearing, you have the right to hire an attorney to represent you for that hearing. You do not have the right to court-appointed counsel for that hearing, okay? You have any questions about early discharge? You'll check in with probation once you leave here. And then you'll be all set, okay? Any additional matters for the record, counsel?
Nothing from the people.
No, Your Honor, thank you.
It's all set. Doreen Jackson here. He's in Eaton County, Mr. Goodrich, so Eaton County, okay, yeah. So we need to treat next week as a PCC.
Your Honor, Mr. Jackson's matter, we just need that step preliminary exam. I went and talked with him at the jail yesterday.
Oh, okay.
And
So you don't need us to treat it as a PCC?
No.
Okay.
he is going to be there next week. My understanding he's going to be there until at least June.
Is that- you have to get rid of it. Oh, yeah, I don't know if we get rid of him that quickly, but we'll see. He's in Eaton County?
Yes.
I think they usually say Alpharetta. They- Okay. Go back there and then. Is our attorney still in the breakout room? And are they gonna put Thomas back in here? Oh, Gary Thomas? I don't know why it does that. Okay, on the record in the matter of the people of the state of Michigan versus Gary Thomas, file number 24-01328. Counsel, can I have your appearance?
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Gary Thomas this morning, Your Honor.
Okay, Mr. Thomas, today was the date that was set for probable cause conference. You have felony pending, 1 count of aggravated indecent exposure. And so my understanding is that there's going to be an unconditional waiver of the exam, which is scheduled for next week, May 23rd at 8:30. Is that correct?
That's correct, Your Honor.
Mr. Feigelson,
That's correct, Your Honor.
was there an offer?
There was, Your Honor, and it's my understanding that he will be waiving up in consideration of this offer. The offer is to have Mr. Thomas be screened for 30th Circuit Court mental health court, and then have him enter the mental health court if he is found eligible.
That's correct, Mr. Feigelson?
Yes, it is, Your Honor.
Okay, and Mr. Thomas, you understand that you have the right to have a preliminary examination in this matter here in the district court? Can you hear me, Mr. Thomas?
Yes. Yep, I
Do you
understand.
under- Okay, and you have the right to have the prosecution meet their burden to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? Can you say it again? Can you stand up because it's not picking up your voice?
Yes.
Do you understand? Okay. Anybody threatening you to give up your examination?
No.
Has there been any promises made to you in exchange for you waiving your preliminary exam?
No.
And you understand the waiver is unconditional?
Yes.
Okay. Okay, your bind over date's gonna be May 29th. That's the date the circuit court will get the file from the district court. You do not need to appear in circuit court on the 29th unless Mr. Feigelson is filing a motion for you to be rearranged at the circuit court level, okay? Do you have any questions for the court today?
Nope.
Any additional matters for the record, counsel?
Nothing for the people.
Nothing on behalf of Mr. Thomas today, Your Honor. Thank you.
You're all set.
Thank you, Judge. Have a good day. We'll see you tomorrow.
Same to you.
Yep.
This shall bell, let's continue. Is that what you said?
That's up here, she is. She hasn't shown.
Oh. So which matter were you waiting for? Ms. Smith? You all set?
I'm all set, Your Honor. I'm just visiting today.
Oh,
May I approach the bench briefly before I leave?
yes. Okay, on the record in the matter of the people of the state of Michigan versus Heather Lombardini, file number 24-00510. Who's in the window?
The two of them. It was left on.
Okay. Vincent Garner, what's going on with that one?
That one is also left set. Mr. Gardner was here, and next week will most likely be a plea.
Okay, on the record in the matter of the people of the state of Michigan versus Cody Har, file number 23-03462, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people. Karen Robinson, Assistant Public Defender for Mr. Hart.
Okay, Mr. Har, can you hear me? The device Mr. Har is on is muted.
Sorry, okay. Say yes, you're here.
I'm Hal.
Okay, thank you. Okay, today was the date set for an arraignment on a bond violation. I do have a memorandum here indicating that on or about April 22nd, 2024, Mr. Har was arraigned by Magistrate Stephanie Godsey at the 55th District Court on the following offenses: count 1, assault with a dangerous weapon, and count 2, a police officer assault resisting obstructing, and that these would be in violation of his bond conditions on this file, which is not to commit a new criminal offense while out on conditional release. So Mr. Har does have the right to have a contested hearing. He has the right to be represented by counsel at that hearing. And Ms. Robinson, you met with him today, correct?
I have met with him previously, Judge. He is being referred for competency on both this file and the file that was issued in 55th District Court. So at this time, I would ask the court to hold the bond violation in advance until the status of the competency exam comes back.
Or went to a plea of not guilty on his behalf, and this will be set after we get back the report from competency. It looks like he's scheduled for review on July 2nd. I don't know if he's actually met with him yet. Did he have an appointment yet with the Forensic Center?
No, not that we are aware of, ma'am.
Okay, so I don't believe he has had one yet.
In his 55th Circuit or 55th District Court case, I know that they're set for review on August 6th. So I think that they're not anticipating getting that report until around that time.
Well, we just all set it, out at a certain time for just for us to follow up. The review is really mostly internal. So we're gonna send an email to forensics to find out if they have something set. The 55th case obviously came after this one, so we had already had him referred since March before he was arraigned on this one, the new one. So we'll see if we can get an update as to when he's gonna be scheduled and if we need to have a review date on the second or not. We'll keep you posted on that, Ms. Robinson and Ms. Petrowski. Any questions for today, Mr. Har?
No.
Any additional matters for the record, counsel?
Nothing from people. No, Your Honor, thank you.
Thank you, you're all set.
Thank you, Your Honor.
You're welcome.
Thank you.
Wyndham, continuing on Wyndham.
Wyndham was gonna be a waiver.
Is Wyndham here?
He's on Zoom.
Oh, okay. On the record in the matter of the people of the state of Michigan versus Tavion Wyndham, file number 23-01352, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people. Karen Robinson, Assistant Public Defender for Mr. Wyndham.
Mr. Wyndham, you can hear us correctly?
Yes, ma'am.
Okay, today was the date and time set for probable cause conference on one count of carrying concealed weapon. And counsel, is there an unconditional waiver or are we just waiving the 21 days?
No, this is an unconditional waiver up to circuit court, Judge.
Okay. Mr. Chomsky.
The people also unconditionally waive the right to a preliminary examination and ask the case be bound by this charge.
Is there not?
There is currently not an offer, per our office policy on CCW charges, that potential offer negotiations will continue upstairs at circuit court.
Okay, sounds good. Okay, so Mr. Wyndham, do you understand that you do have the right in this felony matter to have a preliminary examination in the district court?
Yes, ma'am.
You have the right to require the prosecution meet their burden, which is to establish they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You're willing to waive that right
Repeat that
unconditionally
one.
today?
Repeat that one more time.
Yes, you have the right to require the prosecution to put forth evidence that would satisfy the standard of probable cause. So they have to prove that they have probable cause sufficient that a crime was committed and then probable cause sufficient to charge you with the crime. Do you understand that burden and that right that you have?
Yes, yes.
Oh, okay, and you wish to waive that right to have that hearing in the district court? Meaning you want to give up your hearing?
Like, as in, like, the guy comes in and
No, as in the prosecutor would have to put forth evidence to show if they even have probable cause to charge you with this felony.
That was the hearing that we were talking about.
oh, okay.
Do you want to give up that hearing? Or do you want to have your hearing? It's up to you. And if you need more time to think about it, we can talk about that next week and you'll have time to think about it more if that's what you want.
Yeah, I want to think about it because I want to think about it now.
Okay, yep, we'll put that, you should think about it before you waive any of your rights. And be confident before you do that. So what I'll do is, I will note that you're still considering, and that we'll continue to exam next week. You have the absolute right to have your exam, or you may decide, I don't want the exam, but it's up to you to decide with counsel of your attorney, but it's even with your counsel's opinion and suggestion, it's still your right to waive. She can't waive it for you. So you have to make the decision, okay?
Yes, absolutely. Because I mean,
No
like,
need to
like
go
I,
into any further explanation.
Yeah, don't say
Okay.
anything on the record that could be used against you, okay?
okay.
Okay, so we'll see you next week. You appear in person at or on, I should say, May 23rd at 9 o'clock in the morning, unless you decide before then and you confirm with your attorney confirms with the prosecutor that you are going to waive. But if you're not going to waive, you're gonna appear in person and we'll hold your exam, okay?
Okay, so like if I do waive, it's just gonna, like she said, it's just gonna boost it up. Like we're gonna, like, the case is gonna get handled quicker.
I can't tell you that the case is gonna be ending quicker. The thing is that your case is, you're tying it up 1 week, not a major, there's not a major delay going on. So either it's going to be bound over today, or you'll have your hearing next week to determine if there is sufficient probable cause. At that hearing, one of two things could happen. There could be sufficient probable cause, and if there is, then the case will be sent to the circuit court for further prosecution, or there may not be sufficient probable cause, and then the case is dismissed.
Okay. Well, yeah, we could wait.
Okay, so you think about it, you talk about it more with your attorney, and then we will see you next week with your decision, okay?
Okay, sounds great.
All right, any additional matters for the record?
Nothing for the people. No, Your Honor, thank you.
You're welcome. That was window. Is Chavez Tower?
I believe she's on Zoom.
Okay, on the record in the matter, the people of the state of Michigan versus Chavez Tower, file number 24-01140, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people. Aaron Robinson, Assistant Public Defender from Ms. Tower.
Mr. Wyndham, you're free to go. And then Ms. Tower, please start your video. Very good. Today's the date and time set for a probable cause conference on count 1, assault with a dangerous weapon, and 2 counts of domestic violence. How are we proceeding?
Yes, Your Honor, we'd like to leave this set for preliminary exam next week.
Matter scheduled for a preliminary examination, May 23rd, 9 o'clock in the morning, in person at the court. Do you have any questions for the court today, Ms. Tower?
No.
Okay, any additional matters for the record today, counsel?
Nothing for the people. No, Your Honor.
Okay, we'll see you next week, ma'am.
Okay, thank you.
You're welcome. You're free to go, Ms. Tower. Who's representing Mr. Etheridge? Is Etheridge here?
Yeah.
This client is on Zoom. Ms. Tower is free to go. Let me help her out here. Okay.
And I know it's hard to see with your computer, but Mr. Zaney's here for Carberry.
Oh, wow, Mr.
So,
Zaney, no
he's
one
hiding
told
right
you,
now.
huh? If you sit back there, I won't know that you're there.
Oh, it's all right.
Yeah.
Listen,
Because
I thought
do you
my
see
screen-
how big this screen is?
Yeah, you see how big I am?
You're not bigger than the screen.
I always hide out there on this.
No, it's a terrible thing they did there. Oh, thank you. It's a terrible thing because I can't see over it. Okay, you're here on which matter?
I'm Miss Carberry. I think you want to.
Yeah, is it okay if we meet off the record about, like, there's a couple things we wanted to address?
Okay, give me just a moment. On the record in the matter of the people of the state of Michigan versus Heather Lombardini, file number 24-00510, counsel appearance.
Good morning, Your Honor. Steen Grand, P51260, Assistant Attorney General on behalf of the people.
Your Honor, good morning. Tom Cranmer, appearing on behalf of Ms. Lombardini, who is with me on screen as well.
And I do see Ms. Lombardini present via Zoom. Today was the date and the time that was scheduled for a probable cause conference. We had previously addressed the timeline issue, and it was scheduled for a preliminary examination on July 12th. My understanding is that we will need to move that date out further, but are we still continuing to exam?
Your Honor, we are. The court may be aware that earlier this week, we filed a fairly extensive motion to dismiss the case. I've had the opportunity to speak with Ms. Grand about that a bit, and I think with the court's permission, what we'd like to do is to agree upon a briefing schedule with regard to the motion, and then set the matter for argument if the court wants to hear argument on the matter, and then depending upon how that is resolved, then we could move forward to the exam or not.
Your Honor, I have received the motion, and while I would be happy to just file a response and hear and receive your decision, I believe Mr. Cranmer wants argument. And then based on the decision of Your Honor, we could then decide whether we're going to proceed to exam. So I believe it needs to be decided before the exam. Would you agree, Mr. Cranmer?
I do. Thank you.
Okay, so you've received the motion, and we do have a copy of it here in the court file. And counsel for the AG, when will you have your response, or how much time do you need for a response, I should say?
Can I have, where are we? Can I have till the end of June, Your Honor?
We have no objection to that, Your Honor. And we'd simply ask for 10 days after the response to be able to file a reply brief.
I'll give you till June 28th for your response, and then we'll get a response back from the defendant no later than the 8th. We can keep the July 12th date for a hearing.
Your Honor, with the court's permission, could we perhaps move that date? I've run into a conflict on the 12th.
Okay. Sounds good. We're just gonna we'll just do a hearing on the motion. Does July 25th work?
That would
At
work.
1:30?
That would work for me if it works for Ms. Grand and Ms. Lombardini.
It works for the people, Your Honor.
I see Ms. Lombardini indicating it will work for her, so that would be just fine.
July 25th at 1:30.
Yeah.
Okay, any additional matters for the record today?
None on behalf of the defense. Thank you, Your Honor.
Did the court want to schedule a new preliminary examination date, or do you want to wait until the 25th to make that determination if it's going to be needed?
It's August 8th. We have it scheduled now for August 8th at 9 a.m. unless you have a conflict with that date. Counsel.
All right. No, that would be fine, Your Honor.
We can do August 8th.
Okay, so that's the date. We'll have it set for now, and then obviously we can address it if necessary, if it's going to continue to exam. Any additional matters for today's record?
No, Your Honor. Thank you.
No, thank you very much, Your Honor.
Thank you. You're all set.
All righty.
Professor Cramner, good morning. Not sure if you can see me. Sorry, that's my professor. I said, so.
Professor Kramer, I think we have a Edward Zaney here that wants to say good morning to you.
Very good. Good to see you.
Nice, always a pleasure to see you. 90% of the reason I'm a good attorney is because of you.
Well, that's kind. Thank you so much.
Of course.
Thank you, Your Honor.
Thank you. Have a good one. Let's stand. What's up with his bond? Let me see. Was he remanded for something?
Yeah.
What was his
Joe's
bond?
note is on the front. Right here.
Let me see. Remand for PSI and assessment. They met with him. His bond was previously what? It was- From this file?
5,000 PR.
Okay, Mr. Lee, your bond is gonna be reinstated at 5,000 personal recognizance, okay?
Yes, ma'am.
All your previous
sir.
bond conditions will continue, and you're all set for today.
Thank you.
You're welcome.
I'm sorry, was that cashier or
Personal recognizance.
personal? Okay.
Stats. We'll see if she needs to meet with him while I run to the little girl's room.
So update on Mr. Alexander. He was released from Lenawee County, so he's supposed to be here via Zoom. And then Donnelly is has an 8:30 PE that hasn't gone yet in Flores, where I think they're bringing her guy up from jail right now.
Okay.
So I told her I would email her once Judge got back on the bench, and
Okay.
but at least with Alexander, we're gonna have to ask for an adjournment because my victim's in rehab.
Oh.
She'll be out soon.
Sounds like she's talking to her right now.
Oh, okay. And walls are closing.
Anybody on Zoom? Good morning. What's your name on the Motorola?
Miguel Kelly.
Nope, not you, Mr. Kelly, the other
Sorry.
device. We have your name. What's your name on in the red shirt on the Motorola device?
Patrick Alexander, ma'am.
Okay, thank you. Okay, on the record in the matter of the people of the state of Michigan versus Patrick Alexander, file number 24-00681 FT, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Patrick Alexander, who is appearing separately by video. Mr. Alexander, you need to unmute yourself.
Okay, sorry about that, ma'am.
Okay, no problem. Okay, so today was the date originally scheduled for, it was not originally scheduled, it's scheduled for a probable cause conference. He was originally scheduled for probable cause conference on May 2nd, but he was, I think, in custody in Lenawee County. I don't know if I did at the time, but the court, due to that, is finding good cause to go beyond the 21 days. Because this matter was set for preliminary examination now on May 23rd at 9:30 in person at the court. Are we continuing?
Your Honor, I found out yesterday that the one of the named victims in this case, Miss Kathleen Curley, she is currently at an inpatient rehab program. So she'll be out of that at the end of May, from our understanding, and we've had good contact with her, so people would be asking for a good cause adjournment.
We'll reset that. August 1st at 9 a.m.
That should be enough time.
Okay. Did you hear that date, Mr. Alexander?
Yes, ma'am. August 1st, 9 a.m. Thank you, ma'am.
No problem. Any additional matters for today's record?
Nothing from people.
Nothing for defense.
You're all set, sir. Thank you.
Thank you. Y'all have a good day.
Same to you.
Yes, ma'am.
What's your
Baby.
first language? Your primary or country? Or like, we have a lot of, You're Swahili, okay, all right. I'm learning a lot of Swahili because we have so many clients.
Yeah.
It helps. It does.
I had a victim meeting where we had to use language line where it was just this on Monday where she only spoke Swahili and she.
Okay, now wait, Francis,
That was the language you spoke.
and I see Michael Bengstein.
I appreciate that.
Be that person, so I'm like.
Good morning.
Okay, Mr. Bengstein, you're on here for LVMV funding, correct?
That's correct. That's correct.
Okay, we don't have anyone in the hallway, do we? I don't see the defendant present at this time. Let's see if they're in the hallway. And then I see Miguel Kelly, who is here on the LVMV funding for that one. Is that you, Ms. Francis?
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record.
Okay, and this was a motion for summary disposition that was filed. Let's see.
No one present in the hallway, Your Honor.
Thank you.
I'm sorry, Judge, I didn't hear the last thing you said. Were you?
I didn't say anything.
Okay, did you want me to proceed with our motion?
I've not yet called the case yet.
Oh, okay, I'm sorry.
No problem. How come my number is so slow? Okay, there it goes. Okay, on the record in the matter of the LVNV Funding LLC versus Miguel Kelly, file number 2302716 GC, council appearance.
Navjot Francis on behalf of plaintiff's attorney of record, P72322.
Okay, and Mr. Kelly, state your name for the record, please.
Miguel Kelly.
Okay, Mr. Kelly, today was the date set for a motion for summary disposition. This was filed by the plaintiff. Essentially, they have indicated that you have not presented a valid defense to their claims, and that your answer by itself would not overcome their pleadings and proofs, nor have you demonstrated that you owed a different amount. So they're requesting the court to enter summary disposition, meaning rule in their favor on the amount that they're seeking. I don't see where we received a response from you. Did you file a response?
Yes, ma'am. I went downstairs that same day when he told me to go down and write it. And when I talked to the clerk down there, she pulled it up and printed it out. I had to send an email, and they found that email, and then she said she was going to get that up to you right away on that day.
Let's see. Notice here, correspondence. Okay, I think they entered it as a correspondence. That's probably why. Okay, you disagree with summary disposition. You request for the judgment in the amount of $621.90 and wish to take this to court. I'm not following. Are you stating that you believe that you owe $621.90?
No, that I don't. That I don't owe any of this. That I've been fighting this. This is the third debt collector.
Your statement is for a request for judgment in the amount of $621. So did I misread that, or did you not write it properly? You mean that you dispute the amount owed?
Yes, I dispute it.
Okay.
I apologize.
No problem. Counsel, did you get a copy of his emailed response?
We did get a copy of the email.
Okay. And so did you want to respond to his response because he is disputing the amount?
Judge, I believe in his response, he actually admits he used a credit card. Then when he tried to make a payment, it would not process. So I think that's an admission that he did use the card. He does owe the debt. He did not make the payments to pay this off. So again, we would just ask for our motion to be granted at this point.
You said accepting payments, then a few months later, they just stop taking payments and then go after them. I have fought several debt collectors and have tried to collect the amount, and each have dissolved that collection account, and therefore, are you disputing that you used the card for the amount that they claim that you owe, sir?
I'm disputing that they wouldn't take my payments. I used the credit card and I made a payment. I would use it, and then on the third payment to make, they froze my account and they wouldn't accept my funds. So then I used my wife's debit card and they wouldn't accept the funds. So then I used my grandmother's debit card and they wouldn't accept my funds. And they said the account went to collections unless I gave them my full bank account, my full bank, my routing and everything. Okay.
Thank you. Ms. Francis, what is the amount that you believe he owes?
The damages are $621.90, and plus the court costs and statutory attorney fee, Judge.
Okay, so Mr. Kelly, you're not saying that you didn't use $621.90 on their card. You're just saying that when you tried to pay it, that they didn't take the payment?
The total 620 is they added interest when I wouldn't. They wouldn't take my payments because I was on time with the first two payments. And then on the third attempt is when they wouldn't take it. So then, of course, all the interest and late fees would occur.
I get it. So Ms. Francis, then there he does dispute the amount then. And so I'll put you in the private meeting room. It does sound like there's opportunity for some resolution because he's not disputing that he didn't make a payment. He's disputing that you all wouldn't accept his payment. At least that's his position. And because of that, additional interest accrued. And it sounds like he's willing to pay what he believes he owes, but he doesn't want to pay any interest to the extent that he was in fact not allowed to make a payment and then interest accrued. But I'll let you all talk about that off the record, and then if you're not able to make a resolution, then I will make a determination on your motion.
Thank you, Honor.
We put you in a breakout room.
Okay, thank you, Your Honor.
No problem. On the record in the matter of LVNV funding versus Clement Marciniak, file number is 17-03520. Council appearance.
Good morning, Your Honor. Michael Bengstein, P 69778 on behalf of LVNV funding.
Okay, today was the date set for a motion. This motion was filed by the defendant as a motion to set aside a default judgment. They stated that they were never served and that when they say because I was living at an address, they say. Also, I believe that this credit card has a statute of limitations on it, is what the motion indicates, not exactly comprehending the basis of the motion. Nonetheless, this matter was scheduled for a hearing today at 10 o'clock on the defense motion. The defendant has failed to appear via Zoom or in person. Their motion is denied.
Your Honor, I would like to put a little bit on the record because even if defendant had shown today, we would have prevailed. We would have defeated that motion. I would like to throw a little something on there. So if they try to file such a motion again or have some kind of reconsideration, that there was an adjudication on the merits, if you wouldn't mind. I'll keep it brief.
Okay, well, I don't see where you filed a response to their motion. And so you want to now put something on the record and they would have no knowledge of it because you didn't serve them with a response to their motion.
Fair enough, Your Honor. I will, a win's a win. But he was personally served. That shows on the docket, and it was within the statute of limitations when it was filed. Although I understand if those comments will be disregarded, I just wanted to kind of throw that out there.
They won't be disregarded. They're just here on the record, but I don't think that would prevent him from potentially coming and filing something else. But to file a motion and then not appear on your own motion date, it's not very helpful for his motion to reconsider this denial of his motion. And I'm denying it based on even what he stated, which didn't make much sense reading it to me. It says he was never served when they say because he wasn't living at the address that they say. I do have a proof of service in our file indicating that he was served in person, personally served. Summons a complaint and an attachment back in November 2017. And so.
Well, then we're on the same page, Your Honor, because I can tell based on your comments that you made an adjudication on the merits, that it wasn't simply because he didn't show up. Thank you very much, Your Honor.
No problem. In addition to that, this motion is set aside a default from 2017. And so we wouldn't have granted that motion. It's not timely filed. So that motion is denied. You're all set. Thank you.
Thank you, Your Honor. Have a great day.
Thank you. That one is all set. And then I see Mr. Kelly and Ms. Francis are here. We're back on the record in the matter file number 23-02716 GC. Did you all come to a resolution at all?
No, ma'am.
Just one moment, Judge, I'm sorry.
Oh, okay.
Sorry, Judge, I am back.
Okay, counsel, my understanding is that you did not come to a resolution.
Correct, Your Honor, we did not.
Okay, and so the motion for a summary disposition is denied, and that is because he disputes the interest amount. And so I will proceed to a trial if necessary for proofs to be put on to see that whether or not he owes the amount in interest.
So Judge, I think if I could just make some arguments, our statements show the interest and show that no payments were made. He had issues.
I recognize that your statements show that I recognize your statements show that he has a defense. His defense is that he tried to make payments before the interest accrued is what his position is, and that those payments were not accepted. So he would have to have an opportunity to put forth his proofs for that. And so there is a question of fact. Therefore, a summary disposition would not be appropriate. So I completely see that you all have a statement that showed interest accrued. He's disputing it.
But he could have made payments in a different manner. In his own statement, it said that the payment was rejected for insufficient funds.
That sounds like it's a question of fact then. Can you produce a judgment under the 7-day rule, please?
I'm sorry, Judge?
Can you produce a order for this under the 7-day rule?
Yes, Your Honor.
Okay. Do you have any questions, Mr. Kelly?
At the moment, yeah, I tried to make, I want to know what else can I do to go?
I asked if you had any questions.
No, Your Honor.
Okay, so any further evidence or argument, testimony about the underlying issue that's not appropriate for today, we'll do that at your trial if we have one. Is it scheduled for trial already?
And Judge, is there a trial date?
So civil will get a bench trial scheduled for August 2nd.
There's a bench trial scheduled for August 2nd. That's in person at the court. Any additional matters for today's record? Okay, I presume there's no additional matters. You're both all set. Thank you.
Thank you, Your Honor.
You're welcome.